Hello everyone, this is Monalisha Padhi. I am a legal intern at LEXIS and Company, and I am a third year student of Bharati Vidyapeeth New Law College, Pune, and I am pursuing BBA LLB. And today's topic is death penalty. Several sections under IPC deal with the offences punishable by death. When the Supreme Court inquired about its merit, the Law Commission report said it to allow such person to live would be like living one's life in a civilized society, and it is reasonable to terminate such person in order to eliminate the risk of re-offence. The Supreme Court has repeatedly expressed its concern about lack of a consistent basis for awarding death penalty, emphasizing on want of uniformity. However, it is impossible to lay down a standard to fix a degree of punishment, which makes judicial discretion with the recourse to higher courts the best solution. The year 2019 recorded 53% increase in cases being awarded death penalty as compared to 2016. The fourth edition of the Death Penalty in India Annual Statistics, published by Project 39A of NLU Delhi, revealed the number of death sentences awarded for murders involving sexual offences in 2019 was the highest in 4 years. Recently, while hearing a petition, Chief Justice of India S.A. Bobde remarked the rape law changes after Nirbhaya case have been worked. In 1978, the United States Supreme Court was to determine whether capital punishment stood in violation of 8th Amendment of the United States Constitution. The 8th Amendment prohibits the imposition of cruel and unusual punishments. The court decided in the affirmation. Justice Stewart, in his concerning opinion in Furman versus Georgia, observed that the chance of a convict being sentenced to death is similar to that of an ordinary person being struck by lightning, highlighting the arbitrariness in which the punishment was imposed in the United States. The first notable challenge to the death penalty on grounds of constitutionality came up in the case of Jagmohan Singh versus State of UP. In this case, one of the arguments was that Section 302 of the Indian Penal Code granted uncontrolled discretion to the judiciary and has rendered the provision unconstitutional. However, the same argument was rejected by the constitutional bench of the court. It was held that the legislature has granted wide discretion to the judiciary, recognizing that it is impossible to lay down comprehensive guidelines for the exercise of such discretion, and that judges have been using this discretion since the inception of IPC on the basis of well-recognized principles. The court also referred to certain judgments which mentioned that this judicial discretion was not arbitrary in nature, as such case was unique, and an argument based on discrimination could not be accepted. Another reason that the court gave the confidence to be reposed in the availability of appellate review. It noted that if a subordinate court made an error, then the higher could always rectify the same error in the appeal process. The next challenge to this discretion came up in the case of Rajendra Prasad vs. State of UP. The court in this case held that in the absence of principles, the capital sentencing discretion of courts would be unconstitutional. The court also challenged the use of phrase well-recognized principle in the Jagmohan case by questioning the vagueness relating to it, as the judges would differ on what these principles are. It was held that it would be dangerous to use those words unless a specific meaning was assigned to them. However, this judgment could not overrule the Jagmohan judgment because it was delivered by a 3-judge bench and Jagmohan was a constitutional bench. Between these two judgments, a major development took place. A new code of CRPC was introduced by replacing the 1898 code. While the 1898 code considered the death penalty as the rule and life imprisonment as the exception, the 1973 code considered life imprisonment as the rule and death penalty as an exception. Hence now, the court required to provide special reasons to justify the death sentence. However, the special reasons were not defined in any manner, and the judges had wide discretion in deciding the meaning of this phrase. This was the basis of challenge in Rajendra case. Thank you. That's all for the topic. Thank you and have a nice day.